Courtrooms are supposed to be spaces of order, professionalism, and calm deliberation. But behind the robes and gavels, emotions sometimes explode. High-profile trials bring intense pressure on everyone involved, from defense attorneys to prosecutors, from defendants to judges. And when tension builds, tempers flare. In this video, we're diving into 7 of the most heated courtroom moments, where judges, lawyers, and even self-representing defendants lost their cool in front of the world. Some were shocking, some chaotic, and all unforgettable.
I am very sorry for what I did, and I have to live with it every day. And that if I were to get a second chance, I will do everything in my power to try to help others. And I am doing this for you, and I do not care if you do not believe me. And I love you, and I know you don't believe me, but I have to live with this every day. And it brings me nightmares, and I can't live with myself sometimes, but I try to push through because I know that's what you guys would want me to do. I hate drugs, and I believe this country would do better if everyone would stop smoking marijuana and doing all these drugs and causing racism and violence out in the streets. I'm sorry, and I can't even watch TV anymore. And I'm trying my best to maintain my composure, and I just want you to know I'm really sorry. And I hope you give me a chance to try to help others. If I believe it's your decision to decide where I go and whether I live or die. Not the jury's. I believe it's your decision. I'm sorry. Yeah.
Nikolas Cruz, the perpetrator of the tragic Parkland school shooting, pleaded guilty to killing 17 people at Marjory Stoneman Douglas High School. The penalty phase that followed was emotionally explosive, culminating in an intense confrontation between the defense team and Judge Elizabeth Scherer. The defense team objected to how the court allowed emotional victim impact statements, which they believed were prejudicial. Defense attorney Melissa McNeil accused the judge of showing bias against Cruz and disrespecting the defense. In a tense exchange, Judge Scherer fired back, accusing the attorneys of demeaning behavior and crossing professional boundaries.
Is designed the way that it was administered in this courtroom. If he would have gotten data, we would not have said one single word about that, and we would have respected the jury's verdict. This is our system of government, Judge, and Your Honor should be maintaining the decorum in this courtroom to prevent these families from attacking our children and from attacking us personally when all we were appointed on this case.
Oh, okay, your objection.
But once you bring in my children, I think that's highly improper.
I didn't even know you have children. I don't know what you're talking about. Your children? What about your children?
For them to comment on my children is highly improper. Before this court to allow that kind of testimony is also improper. I don't remember any comments about any children. And if there was, it obviously didn't, it came and went without me noticing it. Judge, I can assure you that if they were talking about your children, you would definitely notice it.
You need to sit down right now. You're out of line.
As the arguments escalated, Scherer raised her voice and accused the defense of staging a spectacle. She even refused to let one of the attorneys continue, cutting her off mid-sentence and warning she would be held in contempt. McNeil, visibly emotional, accused the judge of undermining their ability to defend Cruz properly. Critics accused the judge of letting her emotions show, while others supported her assertiveness in a high-pressure case. Regardless, this trial gave us a rare glimpse into just how strained courtroom relationships can become when emotions run high.
On my birthday. And we should have been out, celebrating, laughing, enjoying dinner, just doing the usual birthday celebrations. And instead we spent hours fruitlessly searching nearby hospitals for Helena because we were told that she was injured. Someone had mistaken her for Samantha Grady, which was often the case. So we thought she was injured, so we braced ourselves for the worst. And then we went to the North Broward General Hospital, the main hospital, and we asked for our daughter. I mean, the whole family was searching for our daughter. And when we were at the hospital, just by looking at the response, they knew our daughter had died. But they sent us to the Marriott. They sent us to the Marriott Center.
The ripple effects of Judge Scherer's courtroom behavior went beyond the trial. Legal experts debated whether her actions, especially her embrace of the prosecution, blurred the line of impartiality expected from a judge. Ethics panels reviewed complaints filed against her, and although she defended her conduct, critics argued that the optics undermined public trust. For many, the sentencing phase wasn't just about Cruz. It became a litmus test for how courts handle emotionally explosive cases involving mass tragedies, where justice and emotion collide.
All right, members of the jury, have you elected a foreperson? Would you give your juror number, please?
54.
54. And has the jury reached a verdict as to each count of the information?
Yes, we have, Your Honor.
One verdict and one verdict only.
Yes.
Would you hand all of the paperwork to the bailiff, please?
This is the ones that you didn't know.
Everything.
Okay.
Yeah, thanks. May I see that too, please, Mrs. Chairman? Thank you.
The trial of Kyle Rittenhouse, who fatally shot 2 people during the Kenosha protests, was one of the most divisive in recent history. While public attention focused on Rittenhouse's testimony, one of the most explosive moments came when the judge lashed out at the prosecution. When Assistant District Attorney Thomas Binger began questioning Rittenhouse about his right to remain silent, Judge Bruce Schroeder erupted. He pounded the bench and yelled, "Don't get brazen with me," accusing the prosecutor of violating Rittenhouse's Fifth Amendment rights. It was a shocking moment of courtroom drama, played live across national broadcasts.
The defendant will rise, face the jury, and hearken to its verdicts.
State of Wisconsin versus Kyle Rittenhouse. As to the first count of the information, Joseph Rosenbaum. We, the jury, find the defendant Kyle H. Rittenhouse not guilty. As to the second count of the information, Richard McGinnis, we, the jury, find the defendant Kyle H. Rittenhouse not guilty. As to the third count of the information, unknown male, we, the jury, find the defendant Kyle H. Rittenhouse not guilty. As to the fourth count of the information, Anthony Huber, we, the jury, find the defendant Kyle H. Rittenhouse not guilty. As to the fifth count of the information, Gage Grosskreutz, we, the jury, find the defendant Kyle H. Rittenhouse not guilty.
Members of the jury, are these your unanimous verdicts? Is there anyone who does not agree with the verdicts as read? Would you wish the jury polled? No. Okay. Okay, folks, your job is done, and we started just about 3 weeks ago. And I told you it could last 2 weeks and 2 days. This is 2 weeks. This is 3 weeks. You were a wonderful jury to work with. You were punctual. You were attentive. And the forgotten 6 over here who had a very difficult job of keeping from discussing the case during the time that they were sequestered.
This wasn't an isolated incident. Throughout the trial, Schroeder scolded the prosecution multiple times, accusing them of acting in bad faith and ignoring court orders. He even refused to allow some lines of questioning, claiming they were irrelevant or prejudicial. These fiery moments led to public scrutiny of the judge's role in the trial. Some praised Schroeder for upholding constitutional protections, while others accused him of favoritism. The courtroom tension was so thick, it became a story in itself. proving that in high-stakes trials, even judges can lose their composure.
Well, all of you, I couldn't have asked for a better jury to work with, and it has truly been my pleasure. I think, without commenting on your verdict, the verdicts themselves, just in terms of your the attentiveness and the cooperation that you gave to us, justifies the confidence that the founders of our country placed in you. So I dismiss you at this time. You're never under any obligation to discuss any aspect of this case with anyone. You're welcome to do so as little or as much as you want. The media have requested, a number of media sources have requested the ability to talk to you, and they have been allowed to present presentations to you that you'll get in writing, and it's entirely up to you whether you want to contact them. They are not to contact you. If anyone does contact you, and just tell them you're not interested in discussing it, if that's the case. And if anyone persists in doing so, report that to us and it will be addressed, I assure you.
Following the explosive exchange, the public reaction was swift and divided. Supporters of Rittenhouse praised Judge Schroeder for standing firm on constitutional protections, while critics accused him of helping tilt the case in favor of the defense. The judge's ringtone, "God bless the USA," heard during proceedings, only fueled the controversy. Legal scholars began dissecting Schroeder's courtroom style in TV interviews and opinion pieces, turning a local courtroom into the centerpiece of a national debate on justice, gun rights, and the rule of law under pressure.
Thank you. The court will now announce the verdicts. Verdict on count 1. We, the jury, being duly impaneled and sworn, find the defendant Matthew L. Moore not guilty of murder as he stands charged in count 1 of the indictment dated the 26th of August, 2022, signed by all 12 members of the panel.
Matthew Moore was wrongfully convicted of a crime he didn't commit, spending years in prison before being exonerated by DNA evidence. But even after his name was cleared, the legal fight wasn't over, and neither were the courtroom fireworks. During a post-conviction hearing, his defense attorney erupted at the judge, accusing the court of dragging its feet and denying Moore the justice he deserved. The judge appeared indifferent to the delays, which infuriated Moore's attorney. At one point, the lawyer shouted, "This man spent years in prison for a crime he didn't commit, and you act like this is just another case on your docket." The judge responded sharply, warning the attorney to calm down and maintain decorum.
Verdict on count 2. We, the jury, being duly impaneled and sworn, find the defendant Matthew L. Moore not guilty of murder as he stands charged in count 2 of the indictment, dated 26 August 2022, and signed in ink by all 12 members of the panel. Verdict on count 3. We, the jury, being duly impaneled and sworn, find the defendant Matthew Moore not guilty of felonious assault as he stands charged in count 3 of the indictment, dated August 26, 2022, signed by all 12 members of the panel. Ladies and gentlemen, I cannot personally enough express my appreciation for the time and the attention you have given to this court during the course of this trial. This is one of the longer trials that occur, and you all were willing to give your time and absolute attention to this matter, and you certainly received the thanks not only of this court but the community as well for your service. As I said earlier, and I believe it again, your participation has strengthened and fully served our institution of justice.
But the attorney doubled down, saying, "Justice delayed is justice denied," and Your Honor, this delay is a disgrace." The courtroom fell silent. The judge threatened contempt, but the message had been delivered loud and clear. Injustice doesn't just end with exoneration. Sometimes the legal system fails victims a second time. Moore's case became a symbol of how bureaucracy, indifference, and courtroom power struggles can prolong suffering for the wrongfully accused.
In this county and everywhere else, for that matter. So we have now concluded your service to the court in this matter. I will, I guess number one, I'm going to share with you, you are released from your admonition. So now you may speak to anyone that you wish about this matter. You may review anything that's been going on. It's entirely your prerogative. I will now discharge you, and you can go back to the jury room. I will tell you that I would like to go back and speak to you privately if you're willing to do that. In other words, if you wish to leave, you're certainly entitled to do that. If you'd like to go back, when I concluded my business here, I'll briefly go back and speak to you.
As Moore quietly stood by his attorney during the fiery exchange, the emotional weight of his wrongful conviction was palpable. Cameras captured the moment he blinked back tears, perhaps a mix of relief and disbelief that someone was finally yelling on his behalf. Public support poured in after the video aired, with advocacy groups citing Moore's case as yet another example of how the justice system fails the innocent. The outrage in that courtroom echoed beyond its walls, helping generate momentum for reforms in post-conviction compensation laws.